Welcome to the third of 5 installments in the webinar series titled Enhancing the Value of Growing Private Equity Platform Companies via Proactive Compliance Initiatives. Today's program will address and provide guidance on proactive employment compliance. Before we begin the presentation, please note that today's webinar is being recorded and participant phone lines will be placed on mute throughout the program. You're welcome to submit questions directly to the presenters during and after the webinar. Their contact information will be displayed at the end of the presentation. In 2 to 3 business days, Epstein, Becker, Green will email registrants a link to access a recording of today's program and PowerPoint materials. Joining us are 3 Epstein, Becker, Green attorneys. Peter Steinmeyer is a member of the firm in the Employment, Labor, and Workforce Management practice. His experience includes advising clients on the enforcement and drafting of non-compete, non-solicitation, and employment agreements, and on the movement of employees between competitors. He has also provided counsel on workplace discipline and discharge, policies and procedures, and accommodation issues under the Americans with Disabilities Act and the Family and Medical Leave Act. Denise Dadika is also a member of the firm in the Employment, Labor, and Workforce Management practice. She has represented employers in state and federal courts and before administrative agencies on issues involving harassment, discrimination, retaliation, breach of employment contracts, wage and hour compliance, tort claims, and restrictive covenants. She has also represented organizations on day-to-day workplace issues, including hiring and promotion, discipline and termination, leave and absence, workplace accommodations, wage and hour compliance, internal investigations, and reductions in force. Paul DeCamp is also a member of the firm in the Employment, Labor, and Workforce Management practice. He has extensive experience in representing employers and trade associations in complex and challenging wage and hour litigations, government investigations, and counseling matters. His work has spanned a broad range of industries, including aerospace, financial services, gaming, healthcare, hospitality, manufacturing, restaurants, retail, and transportation, among many others. At this time, I'd like to turn the presentation over to Pete.
Thanks, David. Good morning, everybody from Chicago. As David mentioned, my name is Peter Steinmeyer. I am the co-chair of EBG's Trade Secrets and Employee Mobility Practice. With my partners, Denise and Paul, we're going to be covering 4 topics for you today. I'm going to start off by talking about potential employment law issues associated with the corporate transaction, including issues such as executive employment agreements, restrictive covenants, severance obligations, and unique issues associated with unionized workforces. Denise is then going to talk about due diligence and ongoing compliance in the MeToo era, and then Paul's going to be talking about pay, equity, and potential wage and hour issues. So whenever I'm talking to a client about a potential acquisition and I'm talking about potential labor and employment issues, I always start off with potential issues with executive employment agreements. Many times, in fact, I would say most executive employment agreements will have provisions in there dealing with what happens to the executive in the event of a change in control. Those are the magic words. And in particular, will that change in control provide good cause for the executive to voluntarily terminate? A change in control can also trigger severance pay or incentive compensation obligations. So that's the very first thing that you need to look at is there a change in control obligation, a change in control provision in an executive employment agreement? And if so, what effect will that have on you as the potential buyer? The second issue that I advise employers to take a look at is the existing restrictive covenants, because many times those are critical not only to maintaining the stability of the workforce, but to maintaining the stability of client and customer relationships. And so the issue is, post-acquisition, will those restrictive covenants be assignable? Now, if this is a corporate stock deal, it's generally not an issue because contracts flow with the corporation just as a matter of law. But if it's only an asset deal, it's very possible that the restrictive covenants may well not flow. The reason being is that you could have multiple buyers of different portions of the assets, and a buyer of some assets is not necessarily the successor to the corporation. So if it's strictly an asset deal, that's something to be aware of. Will the restrictive covenants flow after the closing? Related to that is the next issue regarding restrictive covenants, which is even if restrictive covenants are assignable, are they going to be enforceable? There's been a tremendous amount of statutory activity and a tremendous amount of case law activity over the last 5 to 10 years, in particular over the last 24 months, regarding the enforceability of non-competes. And by and large, pretty much across the country, courts have become increasingly hostile in practice to enforcing non-compete. So even if a non-compete on its face might look to be enforceable, the reality is that when you rush into court and you try and get these enforced, a judge will do just about anything they possibly can to avoid enforcing a traditional non-compete. Now, of course, you've got a traditional non-compete, which is thou shalt not work for a competitor for X period of time, which is different than a customer non-solicitation agreement, which just prohibits soliciting customers, and which is also different from an anti-rating provision, which prohibits you from soliciting coworkers. But, the very first question I always ask is, let's take a look at these agreements. Let's see if they are outdated. Let's see what is the likelihood that they would actually be enforced. And then the other related question is, after the acquisition is completed, will the defined terms in an existing restrictive covenant still be narrowly tailored to meet a legitimate business need? And so the example I like to give is that if somebody's working for Joe the plumber and they have a non-compete and it's legitimate, it's properly narrowly tailored, but then Joe the plumber is purchased by Roto-Rooter with 1,000 locations across the country and that does business across the country, would the definitions in the non-compete that Joe the plumber in a single location had still be appropriately narrowly tailored post-acquisition? Those are the kinds of issues to be aware of. But related to that is the threshold question of whether new restrictive covenants will be needed to protect the business. If you're going to need a new restrictive covenant, the question arises, okay, what is going to be the appropriate consideration? This is one of the areas where courts are taking a closer look at non-competes in recent years, and they're really focusing in on whether a non-compete is adequately supported by adequate consideration or not. And, judges are very reluctant to enforce a non-compete and require somebody to sit out, not get paid, not be able to support their family, especially if they haven't received any consideration or adequate consideration. So that's the first question is, if somebody's going to need to sign a new non-compete, what will be the consideration for that? And will mere continued employment be sufficient consideration? In some states it is, some states it isn't. The trend is toward you need continued employment for a certain period of time and or other consideration, but it's something to be aware of. Another issue to always think about is what state's law is going to govern any new restrictive covenant, and is there a plausible connection between the chosen law and the particular situation? Again, issues to be aware of, issues to think of. Now, whenever a company is doing an acquisition, frequently the most valuable thing, and I hate to call people a thing, but the most valuable thing that they are acquiring is the workforce. And so how does the acquiring entity ensure continuity of the workforce? How do you lock them down? And so as the buyer, you need to look into first, market compensation. Are the key people paid adequately? Are they paid fairly? Because the bottom line is, no matter what industry, if somebody isn't paid their market value, they're not going to stay. Is there incentive compensation, which induces them to stay or locks them down? Are there confidentiality provisions in place, or are new ones needed to protect your trade secrets? Is there a contractual term of employment that locks them into working for a set period of time? Is there garden leave or a mandatory notice period? That's really what I am pushing my clients toward. I'm tending to push them away from traditional non-competes and much more towards garden leave clauses, which are really just sort of mandatory notice provisions. You have to give us 30, 60, 90 days notice before you leave, and during that period of time, we will continue to pay you, but you remain our employee and you can't go out and compete with us. I'm using those because they're much more likely to be respected by the employee and by their new employer, and they're much more likely to be enforced by a court. So that's something to think about. Do you want to have a binding arbitration clause? Many times, in particular with executive employment agreements, a binding arbitration clause is a good thing to have. It provides confidentiality, can provide speed. Now, in certain states, they are under attack in the sexual harassment arena, and perhaps Denise will talk about the enforceability of arbitration clauses in that context today. But as a general rule, arbitration clauses are something to think about. Paul will probably also talk about them in the context of using them as a way to control wage hour liability. Now, the very first thing I talked about at the outset was that when advising a client that is doing due diligence in connection with an acquisition is I tend to start with the executive employment agreements. And one of the reasons why is you need to know if the transaction is going to trigger severance obligations to your senior executives. A lot of times, a change in control will trigger a severance obligation. It could also trigger accelerated vesting of equity awards. So go into this with your eyes open, know what's going to happen from a financial perspective when you make the acquisition. A related question that is particularly applicable in the healthcare setting where hospitals are frequently unionized is the workforce unionized? If the workforce is unionized, you need to be very aware of potential withdrawal liability issues stemming from changes in contributions to multi-employer pension plans. Some of you may have heard the term MEPA, Multi-Employer Pension Plan Amendments Act, or the concept of withdrawal liability. But an acquirer has bought a company and has been completely unaware of the fact that there's this potential liability out there stemming from unfunded vested benefits in a multi-employer pension plan. So if the workforce is unionized, if the workforce participates in a multi-employer pension plan, you need to be aware of whether or not that pension plan has unfunded vested benefits, because if it does, if you change your rate of contribution to the pension plan, it is possible that you could be assessed a portion of those unfunded vested benefits in the form of withdrawal liability. So it's just an issue to be aware of. It's something to talk to with a traditional labor lawyer. Other potential issues under a collective bargaining agreement, if the workforce is unionized, you have a duty to bargain with employees. You can't just run the workforce the way that you want to. You have a duty to bargain. You have a duty to talk. There are also potential issues regarding bargaining unit successorship. Are you going to merge units? What are the appropriate units? These are all issues that you should be aware of if the workforce is unionized. And again, you'll have a duty to bargain over terms and conditions of employment. Finally, there are frequently unique issues with physician employment agreements. As an initial matter, sometimes physicians have employment agreements with phenomenally complicated benefits formulas. I saw one a few weeks ago where it was so complicated in terms of determining what a physician is entitled to be paid that nobody could figure out what they were going to make without talking to the physician group's accountants, because physician gets charged back for this and charged back for this and credited for this and credited for that. There can be incredibly complicated formulas, but again, you need to know what you're getting into as a prospective buyer. There are, of course, licensing issues in the medical field. It's incredibly regulated. There are also corporate practice of medicine issues. And finally, of course, in the medical field, you have insurance and liability and potential malpractice issues, and you need to be aware of what you're getting getting into before you close on the transaction. With that, I'm going to hand it over to my partner, Denise, who's going to talk to you about due diligence and ongoing compliance in the MeToo era.
Thanks, Pete. We're going to talk about, as Pete mentioned, the importance of uncovering and addressing claims of sexual harassment. Throughout the MeToo movement, we've seen the damage that can result when executives' history of sexual harassment or a company's culture of sexual harassment is discovered too late or is not addressed properly. So understanding the potential exposure through a more robust due diligence process is critical. There are a number of documents and resources that can be reviewed as part of the due diligence process to get a sense of whether or not there is a problem of sexual harassment at the executive level or in terms of the culture of the company. Reviewing pending and threatened litigation serves as a good starting point, can reveal potential issues regarding specific individuals or specific departments where there are issues. And as part of the due diligence process, you can follow up on that to get an understanding of whether the claims have any merit, what was done in response to the complaints, if they were made while the employee was still employed with the entity. Internal complaints also can be very informative, so it's critical to review compliance line complaints, employee complaint logs, to get a sense of whether there have been sexual harassment complaints that have been reported, and to look for patterns. Are you seeing the same bad actors to be alleged to have engaged in the conduct? Are you seeing the same departments? And then to get a sense of what the follow-up was on those internal complaints. Was there an investigation? If there was an investigation, what corrective action was taken? That'll give you a good sense of whether or not the entity takes the claim seriously and takes corrective action when they find their claims do have merit. Another resource is looking at settlement agreements. If you find that there is an unusually large amount of settlement agreements, that could be a potential red flag in terms of sexual harassment issues. If the agreements are addressing sexual harassment, you can identify and ask the entity to give you some more background information to understand, again, if there's a culture here or repeated abuse of sexual harassment at the entity. Other resources besides settlement agreements, exit interviews are also a good resource. Similar to internal complaints, look for patterns of behavior that could suggest there's a culture of harassment that has been tolerated over the years. Again, are the same employees being accused of harassment? Was anything done in response to those exit interviews? Get a sense of corrective action being taken. You can also look at turnover data to determine is it inconsistent with the market for this entity? Does the entity you're seeking to acquire have a problem recruiting and retaining women? That could be a potential red flag. It's also important to look at the entity's current harassment and complaint procedures to understand what the procedure is. Ask the entity, do they train regularly on these practices? That'll certainly give you some information about how seriously they take claims of harassment. And finally, you should take a look at employment agreements for executives and take a close look at the cause definition and see if there's any mention of sexual misconduct. If there's an exclusion for sexual misconduct, that could certainly be a red flag that there has been a lack of enforcement of that element at the upper level of the entity. Okay. Next slide. So in terms of some safeguards, you can enter into what's been recently referred to as a MeToo representation or a Weinstein clause. They can take various forms, but essentially it requires the target company, their equity owners, and their key management employees to represent that within a certain period of time, there haven't been any sexual harassment or assault allegations that have been made against the company or against the key individuals at the company. This can serve as protection if it turns out later down the road you determine and that disclosure that was made to you was false. It provides you some protection in terms of damages against the seller. You can also seek some indemnification provisions as well. Again, if it turns out that these representations were false in terms of sexual harassment or they failed to disclose sexual harassment claims when they were supposed to be identified as part of the due diligence process. Okay, so in terms of proactive compliance initiatives to implement as you integrate the newly acquired company, it's important to ensure that the company on an ongoing basis has an effective sexual harassment policy and has a very effective complaint procedure. The policy should be easy to understand. It should cover everyone, not just employees. You want to make sure it covers contractors and temporary workers. It should encourage early reporting. Even if the conduct ultimately is not actionable, it should be reported so the company can investigate. And there should be multiple forms of raising concerns. A anonymous hotline is critical in terms of having an effective complaint procedure. Oftentimes employees are not comfortable coming forward because they fear retaliation or that they might lose their job. So an anonymous hotline can be very effective in addition to complaining to human resources and management. Training is also essential. So once you put your policy in place, it's important that all of the employees understand what that policy is. And by training on a regular basis, you're emphasizing to your workforce that you have a commitment to honor the policy and protect employees from harassment. It should be tailored to the specific workplace realities. It's helpful to have examples for employees of what is and what isn't harassment so they can understand the concepts, examples of respectful behaviors, and examples of behaviors that do not comply with the policy. I encourage companies to train managers and non-managers separately. Oftentimes, non-management employees aren't comfortable asking questions if managers in the room during a training session. Also, managers are held to different standards and liabilities, and that should be addressed in a separate training session. Managers should be clearly told, and it should be emphasized, that they have an obligation to report any harassment that they see or hear in the workplace, and their failure to do so could result in disciplinary action. I recommend doing the harassment training on a regular basis, and as we've seen with some of the laws that have been recently passed, for example, in New York, you're going to have to do this training on an annual basis to ensure that all employees know what the policy is and, importantly, know what the complaint procedure is so they can complain if they feel like they've been treated in violation of the policy. Okay, so in addition to training, it's also important to have leadership buy-in. They're going to set the tone for the organization, so they need to model the respective behaviors that the company is committing to take to establish a culture of respect. It's also important that HR has the support of the C-suite so they can address and remedy sexual harassment. You may even want to create an internal task force or committee that can identify and address specific problems. Also, creating pathways to diversify leadership and core jobs is essential. The more diverse and inclusive a workplace is, the more likely people are going to feel comfortable complaining because they recognize that there are people like them at the top of the organization, so they're going to feel more comfortable coming forward with complaints. Okay, so now we're going to talk about pay equity from both a due diligence and a compliance perspective. Employers have been facing a growing threat from pay equity claims. We've seen a number of states and localities pass pay equity laws over the last couple of years, and we're going to continue to see more laws as time goes on. In terms of the federal background for equal pay, the Equal Pay Act was enacted in 1963, and it abolished wage disparities based on sex, and it required equal pay for equal work. Through the years, there has been pressure on the courts to broaden that standard to be comparable worth or comparable work, and it just hasn't gotten there. But what we'll see from the local and state laws, we have a much broader definition in terms of equal pay for equal work. We have substantially similar, we have comparable worth. There are a number of different definitions. We also have the Lilly-Ledbetter Act, which essentially extended the statute of limitations to provide that each paycheck was its own discrete discriminatory act, and that person could bring a claim based on each paycheck. All right, so under the federal standard, pay differentials can be justified based on a seniority system, a merit system, a production standard, and any other factor other than sex. It's a much broader definition in terms of exceptions than we're seeing from the laws that have been passed at the state and local level, which making it more difficult for employers to justify any disparate wages across genders and across other protected characteristics. So in terms of the activity we've seen amongst the states and the cities, since 2016, we've seen equal pay or anti-discrimination laws in terms of wage disparity either be passed or amended in California, Massachusetts, Maryland, New Jersey, New York, Oregon, Washington, and Puerto Rico. All of these laws vary, and they all have different standards and definitions, which makes it difficult for employers. So it's important if you're operating at multiple states across the country that you team with counsel to understand what your obligations are in each state that you operate. But I will say this, they're all broader in terms of the protections that they provide for employees than the federal law. Some of them provide broader categories. For example, New Jersey has 20-plus protected statuses. So it prevents wage disparity based on any protected class, not just sex. It could be national origin, religion, disability, etc. Oregon's law is similar. In California, they protect against wage discrimination based on sex, race, and national origin. New York has proposed a similar law. We're also seeing a broader geographic range. For example, in New Jersey, they say the employees can be compared across facilities. So it's not limited to one facility when you're trying to determine are people being paid for similar work. In terms of the different standards, we've gone broader than for equal pay for equal work, and now we have the comparable work standard in Massachusetts, Maryland, and Oregon. In California and New Jersey, we have substantially similar work. So it's more difficult for employees to demonstrate that they're complying with the laws. In addition to the equal pay laws, in addition to the different standards, there's much stiffer penalties. For example, in New Jersey, there is treble damages going back for 6 years of back pay, which is much broader than we see under the federal law. We also have salary history bans that are popping up all over, particularly in the blue states. They've enacted the salary history bans to correct women and minorities from being historically underpaid. The theory is that basing compensation on prior salary continues to perpetuate past discrimination. So we have laws in California, Connecticut, Delaware, Massachusetts, Oregon, Vermont, and these localities here that say employers can't ask candidates how much they're currently earning at their job. Instead, you're supposed to set a wage band for each position at the company. We've seen some movement of some states who vetoed similar laws, for example, New Jersey and Maine at this point, but I think we're going to continue to see these pass over time. Okay, go to the next slide. So what should employers be doing in terms of due diligence? So they should be asking for an employee census to understand what does it look like in terms of job descriptions and salaries and gender to see if there's any disparity, and look at the other protected characteristics if you're in a state that protects against those as well, for example, New Jersey. Look at the job descriptions to understand if there's similar job responsibilities. Understand the compensation policies, how compensation is set. Take a look at applications to make sure they don't have any questions about salary history. You can look at internal pay equity audits that were done if they resulted in demonstrating there has been disparity, and if such, what action was taken. And then finally, look at litigation, complaints or demand letters to see if there's been claims of unequal pay and how they've been addressed. And then in terms of ongoing compliance, really should consider creating compensation bands for all roles. That's going to include factors to consider when setting offers within a range, including education and experience, and document any reasons for high or low range offers. You can also consider doing some pay audits, but I would suggest to you should really consult with counsel when doing those to identify whether or not they can be privileged and how to go about exchanging documentation. And if you're going to do the pay audit, you should commit to correcting any disparities that are found during the audit. Okay, so now I'm going to turn it over to my colleague Paul DeCamp to address some wage and hour issues.
Great, thanks very much, Denise. When we're talking about worker classification of employees or independent contractors, this is sometimes a pretty straightforward matter. There's a lot of settings where the correct classification is going to be obvious. If we're talking about people in a hospital or people who work in other skilled care facilities, it's oftentimes not going to be particularly controversial at all. It'll be pretty clear that whether people are employees or independent contractors. But in some settings, especially when we have networks of geographically dispersed providers, figuring out whether people should be treated as employees or independent contractors can be a real puzzle. And this is an issue that can be an important threshold issue for any kind of acquisition involving independent contractors or people classified as independent contractors. And getting this classification right is important for a variety of reasons, because the status of workers oftentimes triggers the coverage under a variety of laws, such as wage and hour, tax, unemployment, and workers' compensation insurance. There's another wrinkle to this, which is that you can have classifications that within a particular business are perfectly safe, but when you acquire a business that has folks doing the same kind of work but in a different classification, for example, if you have a business that uses independent contractors and you acquire a business that has employees doing the same type of work that the independent contractors were doing, now all of a sudden that could jeopardize the status of the independent contractors in the original business. Let's go to the next slide, please. So with each of these laws, there's a different standard that applies. They don't necessarily use the same test or even similar tests. Under the Fair Labor Standards Act, which is the federal law dealing with overtime and minimum wage, among other things, the court uses, the Department of Labor uses, and the courts have also followed, with a test called the Economic Realities Test. And it looks to a number of factors. We're not going to run through all of them here, but it's important to understand the kinds of considerations that the Department of Labor and the courts look at. One of the most important ones is this first factor, which is the extent to which the services that the worker is providing are an integral part of the principal's business. And that means, are the individuals whose status is in issue performing work that is within the business model of the company or not? And sometimes that's a definitional issue that really confounds the analysis. Another thing we look at is, are the relationships short-term or are they open-ended? Then we look at investment in the facilities. In other words, are the providers or whoever the employees or contractors at issue, are they putting their own money and investment into the work, or is everything being provided for them? Let's go to the next slide. A very important factor by any measure is the nature and degree of control by the principal. And this is an issue that gets echoed in some of the other tests we're going to be talking about as well. To what extent is the company that is maybe an employer or maybe a contracting entity controlling not just what the worker is doing in terms of the output, but the way they're going about performing the activity? The more there is control over the way the worker is carrying out the activity, the greater the likelihood that that individual is going to be found to be an employee. We also look at opportunities for profit and loss. This is important because with a lot of healthcare providers, they're providing services for a fee. And if their only way to increase their profit is simply performing more services for the stated fee, there might not be the opportunity for profit or loss, versus if there's an opportunity to use judgment, foresight, open market competition to structure their provision of services in a way that leads to greater profit, not just by doing more services, but by doing them more efficiently or more profitably, then there might be more of an indication of an independent relationship. And then they also look at the degree of independent business organization. Do we have individuals that are operating an LLC or another entity, or is this just an individual providing services? At a 30,000-foot level, what the economic realities test is trying to sort out is whether the individual, the workers who may be employees or may be contractors, are they functioning more like an independent business would function, or are they functioning more like traditional employees in an employment relationship? Let's go to the next slide, please. Now, the IRS, for federal tax purposes, uses a general rule quote, that an individual is an independent contractor if the payer has the right to control only the result of the work, not what will be done and how it will be done. The IRS used to use a 20-factor test for this. Now they use a 3-factor test that looks a lot like the 20-factor test because each of the 3 factors has sub-factors. But it's important to use the correct standard when we're analyzing these issues right now. Let's go to the next slide, please. The first of the 3 big factors is behavioral control. And that is where we're looking at whether the worker, when dealing with the business, is operating with a business that has the right to direct and control the work that's performed by the worker, even if that right is not exercised. So sometimes there'll be a contract that specifies a very broad right of control, and the IRS right now would say that, well, if the business has the right to control the work and the way the work is done, even if the business doesn't exercise that right, the IRS may find that that's still behavioral control for purposes of this test that would push it more in the direction of somebody being an employee. They also look to financial control, which is, does the business have a right to direct or control the financial and business aspects of the worker's job? And then there's the relationship, which is, how do the parties structure their relationship? Are they structuring it in a way that is more consistent with 2 businesses operating at arm's length, or is it structured financially more like what we would see with a traditional employer-employee relationship? Let's go to the next slide, please. Now, under state law, we see what's commonly called the ABC test. Not every state uses it. About half of the states use it. And for the most part, they use this test to figure out coverage under unemployment and workers' compensation laws. Some states like California and a few others use the ABC test more broadly and use it for purposes of figuring out coverage under their wage and hour laws, so their overtime and minimum wage laws. Under the way that most of the states use the ABC test, a worker is an employee unless the situation satisfies all 3 of these criteria, A, B, and C. The first is that the worker is free from control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. So this is the control. This is if you, as a business, are controlling the way the work is performed, not just the results of the work, but the manner in which it's performed, then under Factor A, you have an employee. Now, Factor B, which is typically the most challenging factor, is that the worker performs work that is outside the usual course and scope of the hiring entity's business. A good way to think about this is if you have a restaurant, well, obviously in the restaurant there's going to be cooks in the kitchen. The cooks are doing work that is within the usual course and scope of the hiring entity's business. This gets more complicated when we're talking about networks of geographically dispersed providers performing, for example, in-home assessments of healthcare. When that's going on, there's sometimes a real question about whether that activity is within the course and scope of the hiring entity's business. Now, in some states, this B factor also requires that the worker must not be performing any of this activity at any of the company's work sites. So that can be a concern as well. And then the C factor in the ABC test is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So in other words, is this just an employee who works for a number of companies, or is this somebody who actually has their own business and is actively seeking new customers and new clients? Let's go to the next test. Here what we see is that there's a lot of considerations to deal with when you have multiple tests in play. You have to look at the law of each state very carefully because there are important variations. You might find that these tests lead to different outcomes, either under different tests or different outcomes for different types of providers within the same business, for example, doctors versus RNs or LPNs. Also keep in mind the restrictions on corporate practice of medicine, which are always a concern for MDs and can be for other providers as well in some states. And then what we see is some states or some businesses try to deal with this issue by setting up different entities in different states and saying, well, in this state over here, we're going to use independent contractors, and in that state over there, we're going to use employees. That can help sometimes, but it doesn't completely deal with the risk. Let's go to the next slide, please. Now, beyond the issue of exempt, non-exempt, we have to deal with, beyond the issue of employee independent contractor, if we're dealing with employees, the next set of concerns is whether people are exempt or not exempt, meaning whether they're overtime eligible or not. Under federal law, licensed medical doctors, there's no concern about how you pay them. But in some states there is, because in a small minority of states, you have to pay physicians on a salary or fee basis. And then when we're talking about fee basis payments, there's oftentimes a question whether fee-for-service qualifies because there are peculiar regulations that we've seen interpreted under federal law and state law that may say that if you're providing essentially the same service over and over again for the same fee, that's not really considered fee basis compensation. That's considered something else, piecework. And so that might not qualify for exempt status. And then that same concern applies when we're talking about all of the other providers below the level of doctor. So we're talking about RNs, LPNs, practical nurses, all of that, nurse practitioners. When we're talking about all of these other providers, they are subject under state and federal law to the requirement of salary or fee basis compensation in order to be exempt. And so it's important to understand the limitations there. Let's go to the next slide, please. When we're talking about these restrictions under federal law, the other concern for exempt status is if you have home health care, it's important to know about the recent changes, relatively recent, October 2013, with regard to the Federal Companionship Services exemption. In 2013, the Department of Labor substantially narrowed the type of work, the number of workers that could qualify for an exemption that had applied to these workers for about 40 years before that. So it's important to be aware of those, both in terms of who is paying for that work and the type of work that's being provided and the amount of work. Let's go to the next slide. When we're talking about non-exempt employees, the most important thing is to make sure that you're accurately calculating and accounting for all of their working time. And the concerns that we typically see in healthcare include automatic deductions for meal periods. This has been a big issue for nurses in hospitals, among other things. Travel time during the day, especially when we have people performing any kind of in-home assessment or care, making sure that we are counting as working time travel between patients' homes. That's very important. Also, be mindful of any kind of paperwork or other activities that employees either do or might say that they do during unpaid meal periods, or that they may say that they're doing at home. These are claims that we typically see in litigation. It's very important to have your policies in place and to monitor for that so that you don't get hit with a surprise claim after the fact. And then training programs. Important to treat those meetings, administrative time, as paid time if we're talking about non-exempts. And then finally, make sure that you're mindful of any local meal and rest period laws which apply in about half of the states. Being aware of those when you have to provide the meals and when you have to provide the rest periods. Have your policies comply with those and you'll be in good shape. So we now have a few minutes remaining for questions and answers.
Thank you, Paul. Thank you, Denise. We've got about 3 minutes, and we've got a handful of questions. Let me take the first one here. And Denise, this is a question for you. Do you recommend zero-tolerance sexual harassment policies?
So, years back, that's what most policies were, zero tolerance. And there's been a strong push from the EEOC to remove that language from policies because it sends the wrong message to employees. Employees feel that zero tolerance means if I complain about someone, they're going to be terminated. So it sometimes chills complaints because the employee who is concerned with behavior doesn't want a colleague to lose their job. Sometimes it sends the wrong message that all employees who are found to have violated the policy will be terminated, and sends a wrong message sometimes to supervisors as well. So I recommend not including that language, but if you are going to use zero tolerance, there should be an explanation in there that if any violation of the policy will be found, the discipline is going to vary depending on the severity of the conduct engaged in. I think if you're going to include it, you should certainly include that explanation so that everyone understands what the policy means.
Thanks, Denise. The next question is one that I will take, and the question is it possible to have a 50-state non-compete agreement? And the answer is not really. 3 states, California, North Dakota, and Oklahoma, flat out prohibit non-competes. Massachusetts doesn't prohibit them, but for new non-competes, it has some fairly strict requirements that you have to meet. Colorado also is fairly tough. So you can draft a non-compete that you could use in the vast majority of states, so long as you sort of draft for the strictest of the states that permit them, but you couldn't have a pure 50-state one. Again, as I mentioned during my part of my presentation, I'm really encouraging my clients to move much more towards garden leave and or pure customer non-solicits and to sort of get away from the traditional non-compete concept. Okay, we've got about a minute left, so I'm not going to be able to get to all of these questions, but Paul, I do have one for you.
Okay.
Is the significance of independent contractor versus employee classification lessened in the current enforcement environment with a federal administration which is perceived as more business-friendly than in the past?
It's an interesting question. I think the risk of federal enforcement is certainly lessened, but we're still seeing a lot of private litigation, private plaintiffs that can bring lawsuits, whether it's under the wage laws or other laws. And we also see a lot of state-level agencies that are eager to step into the breach, because if states can assert that businesses have improperly classified employees as independent contractors, the remedy is typically money that flows into the coffers of the states in terms of tax payments, in terms of workers' comp, unemployment insurance premiums. And so this is a moneymaker for the states. So there's a lot of activity going on below the federal level that still makes this issue one of great importance for businesses.
Well, thanks, Paul. I think we are out of our allotted time now. David, let me turn it back to you.
Thanks, Pete. This concludes today's webinar. A reminder that in 2 to 3 business days, Epstein, Becker, Green will email registrants a link to access a recording of the presentation and PowerPoint materials. We hope you'll join us for the next installment in this series, which is scheduled for next Tuesday, October 23rd at 12 p.m. Eastern Standard Time. Presenters will discuss different approaches to enhancing compliance initiatives for platform companies to employ as they continue existing operations and expand operations by integrating new acquisitions. For more information and to register, please visit www.ebglaw.com/events. Thank you for attending.
Thank you all.